thank you for joining us at the bar for another virtual happy hour conversation about issues at the intersection of law, politics, and culture. I'm Jennifer Braceras from Independent Women's Law Center, and I'm joined by my colleague, Inez Stepman with the Independent Women's Forum. Today, we're going to be talking with one of our country's top appellate litigators, Erin Murphy, who, along with former U.S. Solicitor General Paul Clement, recently represented gun owners in a major Second Amendment case before the United States Supreme Court.
Welcome, Erin. And that case, New York State Rifle and Pistol Association versus Bruen, involved a constitutional challenge to a New York City law prohibiting people from carrying guns outside the home. So this is about concealed carry. And Murphy and Clement, who were Kirkland and Ellis partners, won their case in the high court this past June. But then after their win, Kirkland gave them an ultimatum: withdraw from representing their clients even after this very prestigious, huge win, or withdraw from the firm. So they went ahead and left the firm. They've now started their own law firm, Clement Murphy. But Erin is joining us now to talk about the Bruen case itself, and then this very, I think, critical turning point for the legal profession, for big law, this ultimatum that was issued to them, and their decision to leave big law. So thank you so much for joining us at the bar, Erin.
Oh, my pleasure. Thank you for having me.
Let's start with like the facts of the case itself. Can you lay out for our listeners, what the New York law was, and then how you ended up representing the New York State Rifle and Pistol Association?
Sure, absolutely. So New York, like a handful of states in the country, had many states have some sort of permitting or licensing regime to carry a firearm, but just a few states have, or now for some had, what are known as may issue regimes. So in the world of permitting, we kind of put things in two categories: shall issue or may issue. And in a lot of states, there's shall issue states, which means there's some objective criteria. You got to pass a background check, things like that, pay a fee, whatever it is. But as long as you pass that objective criteria, you get the license and you can carry. And it varies a little by state, whether it's for concealed or open or both. Some states you don't need a license or permit at all. But there were a handful of states that had regimes that operated differently, and basically built into them a requirement to demonstrate that you had something generally referred to as kind of good cause or good reason, which was a discretionary requirement that they then defined as meaning that you had to have like a really good reason to want to carry a firearm. It may even be that you needed to demonstrate something like a documented threat to your safety, like a restraining order, or something beyond just kind of, oh, I work nights, and showing that you had like a very particularized type of job.
And so who were the determiners, or who were the deciding people? Like if you wanted to carry a firearm in New York and you wanted to apply to do that under this law, who would make the decision as to whether or not you had a good reason to do that or not?
Yes, it happened at a local level. So you'd have, which is pretty typical in a lot of, in the states that had these, it'd be at kind of a local level. So what you'd find is, some parts of the state where most people got a permit, and some parts of the state, like New York City, where essentially nobody could ever get a permit. And then these decisions were, to the extent they're reviewable at all, reviewable under a highly, just abuse of discretion type standard, where there was a ton of deference, and the case law had developed such that, if you couldn't come in with that specifically articulable threat to your safety, it was perfectly fine to be denied your right. So you not only had a regime where, you needed to kind of affirmatively demonstrate that you had a good reason to exercise what we have always argued was a constitutional right, but you had built into it this just highly discretionary regime, which is particularly troubling when you're dealing with constitutional rights. You want to have very clear and hopefully objective standards, so you don't have to worry about, even apart from kind of the good cause nature of the regime, about having the ability to exercise fundamental rights just sort of left to the whim and discretion of government officials. So, we had challenged these. We've been challenging these laws for probably about a decade in the couple of the handful of states that have them. And New York's law was one that had been challenged before, and the Second Circuit had upheld the law. After there were some changes in membership on the Supreme Court, we decided to kind of take another run at some of the jurisdictions where these types of laws had been held constitutional. And lo and behold, not that long after Justice Barrett joined the court granted cert to finally resolve this question that had been kicking around for a very long time, kind of almost since Heller, of whether there is a Second Amendment right to carry a firearm outside the home for self-defense. So that was a core issue in the case. And it was not a case, that was specific to concealed or open carry. Our argument was always simply there needs to be some outlet. It can't be that, and the way it operates in a lot of states is like it's categorically prohibited to carry one way, and the other way you could only carry if you have the license that it's impossible to get. So functionally, there's no way to carry. So we were never challenging it specific to a state has to offer open or has to offer concealed. We basically just argued you got to offer something. Law-abiding citizens should have some means to carry outside the home because, as a historical matter, that's just was clearly part of the Second Amendment right.
So this might be a good time to sort of just remind our audience, particularly our non-legal audience, what the Second Amendment says. Inez, I think we have a graphic that we can put up. There it is. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that is what the Second Amendment says. You alluded in your sort of opening remarks, Erin, to an earlier case called Heller that involved the right to have a handgun in the home. That sort of addressed the keep part of keep and bear arms, whereas this case, as you mentioned, was talking about whether one can defend themselves with a handgun outside the home and how states are able to regulate that. Can you just kind of tee up for us, if you will, the sort of the competing arguments by the time you got to the high court, what you argued and what the other side argued, and ultimately what the court decided?
Sure. Yeah. So one of the big kind of lurking questions in all of this was how you should think about resolving these questions. Should you think about that by looking to kind of the historical understanding of the Second Amendment, or should the state kind of get deference in its policy judgments under, kind of thinking about, does it have good arguments about public safety and the like? So there was sort of a debate going on all throughout the litigation of this case about kind of which way to come at it. And by the time we were at the Supreme Court, the state of New York, I would say to their credit, they pretty much agreed that at least the core place the analysis should start is by looking at that historical tradition. And so, a lot of the briefing on both sides focused on trying to make a case that these kinds of restrictions, were or were not consistent with the way the right to keep and bear arms would have been understood at the time of the founding and, not that long after. Now, I think, and the court, most of them agreed that we had by far the stronger argument on that historically. But, the state didn't really kind of say, forget history and only think about policy. They did try to come up with some arguments as to why they thought that their law was analogous to certain types of restrictions. The problem, I think, that we consistently pointed out is, look, while there may have been some degree of regulation of the right to carry outside the home, there's just nothing this is like what the court said in Heller about where they were dealing with a complete ban on keeping a handgun inside the home. Here, too, there's just no historical basis for having essentially a complete ban on the ability to carry a firearm outside the home at all. And so, we argued that you can't take from the fact that there may have been some degree of regulation in certain places or of certain people, that means the state can say, absolutely not. even law-abiding citizens. You just all, most of you cannot carry, period. So that was a big part of the argument. And then the state did argue that, whatever the history said, it should get some degree of kind of deference on its policy views about the importance of having this kind of law in place. So kind of, and a lot of our response to that was actually just, that's not really appropriate in the context of a fundamental constitutional right. There's public safety arguments that can be made about any constitutional right, but we don't typically allow those to override the judgment of the people to enshrine a fundamental right in the Constitution. And so that's kind of the framework through which the arguments were made to the court here.
I don't know if Jennifer wants to jump in with the brief that actually IW and our law center filed that was ended up getting cited in this case by Alito. But so I don't know if Jennifer, do you want to talk about that since that's your?
Sure. I mean, so we filed a brief in support of Erin's clients, just sort of giving a female perspective, if you will. And it was sort of I guess you could call it sort of a Brandeis brief where we talked about the importance of this right in particular for women. And obviously it's a fundamental right that all Americans share, but we talked about how for women in particular, the right to carry a handgun for self-defense, can be very important. And we were gratified that Justice Alito did cite that brief in his opinion. So we were happy about that. But hopefully it was helpful, Erin.
Yeah, that old phrase. Sorry.
I was just going to say, I think it's just really great to have, there tends to be a lot of stereotyping and just assumptions when it comes to Second Amendment issues that, that there's just some isolated small segment of the community that cares about this and that most people don't. So I think, it's hugely important to help the court understand that, that the majority of the country supports the notion of a Second Amendment that protects a fundamental individual right. That's a cross-cutting issue, not something where, only a certain demographic of the country supports the issue. And it's been great. I do a lot of litigation in this space to see amicus briefs from, groups like a women's group that I think for some people will look and think like, oh, that's not quite who I would have expected to see on this side of the issue. So I think it does make just a really important difference in as part of that dialogue that we're always having with the courts.
Yeah, I was going to say that the phrase "God made man, but Samuel Colt made them equal" applies actually more strongly to women, and in a sense, being the weaker sex, we need some kind of equalizer in conflict. But so we've covered the difference between the shall issue and the may issue. Do you think this is like shaky ground going forward based on this case for any of the may issue states or regimes or local regimes? Or do you think it's just you have to be as completely restrictive as New York City has been, where basically nobody, as you said, like basically nobody can get this permit, right? So you can argue very strongly this right is just not functional, right? In this city, it's being denied. Do you think that there will, because a lot of the history, to the extent that the court has picked up Second Amendment cases at all at the highest level, it's been like one big case and then, years where essentially states and cities try to circumvent the most basic holding of that case. So what do you predict is going to happen here with this kind of patchwork regime?
Yeah, so I don't think, I could be wrong, but at least to my knowledge at this point, I don't think any state that has a sort of good cause requirement may issue regime is yet tried to claim that it's still constitutional. Certainly California has their attorney general has said they don't think that piece of the law is enforceable anymore. And I think it's pretty clear under the Bruen decision that having those kind of discretionary permitting requirements is just not okay. There was a separate concurrence and some language in the opinion making clear that the court's not saying you can't have permitting or licensing regimes at all, but they really need to be objective. And there's some great language in the majority opinion about how they can't be, there could still be challenges to them if, say, you set the fees so high as to make it impossible for the average person to afford the license, or, things that create burdens like that. But where I actually think, where what we have seen very quickly from some of the states that have been the most hostile to Second Amendment rights is, one of the lurking issues in the case, because the court ultimately did decide that there is generally a right to carry outside the home. But the court also said that doesn't mean you can carry everywhere. And, we always said it doesn't mean you can carry everywhere. There's doctrine to support the idea that there's certain sensitive places that the government can kind of declare off limits to firearms. That's really where I think, the first wave of kind of new laws is headed, is trying to declare as much as possible to be a sensitive place. And the court actually kind of anticipated this and said in its opinion, look, you can't get around this by claiming that like the entirety of New York City is a sensitive place. But that's nonetheless sort of what New York is now trying to do. There's been a lot of noise about California looking at some similar legislation. And, so I think kind of the next ground will be the next fight in this battle will be kind of what is a sensitive place and how do we think about that historically, and making sure that that the states don't kind of do what they've been doing for the past 10 years with this, which is turn around and pass a bunch of other laws that are designed to say, okay, here's your permit, but we've declared it useless in functionally every place that you'd ever want to actually be able to carry your firearm for self-defense.
So this is obviously a big victory, not just for the movement at large, for people who support the Second Amendment, gun owners, and so on. But it was also, it's a big professional victory, right? Winning a big case like this, generally, I mean, how would you expect a major law firm to celebrate a huge and prominent victory like this?
Well, I guess it depends how much time you've spent litigating controversial issues at a major law firm. But normally, firms like to see you win your cases. That's the goal. This was a hard-fought victory over a decade, and not only one on the Second Amendment, but also an opinion that really has some landmark discussion of the right way to understand constitutional rights writ large that I think will have tremendous implications in a lot of areas of the Constitution. So, if you have a Supreme Court and appellate practice that's focused heavily on constitutional law, like, you like to think this is what people are hoping they'll get out of your practice at your law firm.
And what in fact happened when you won this case?
Well, in fact, our firm decided that they just wanted out of the business of Second Amendment work entirely, and wanted out of the business of Second Amendment work immediately. And even if that meant just dropping existing clients, not only in this case, but in multiple cases where we also, in addition to this case, we had some petitions pending at the Supreme Court that the court was basically holding for this case that, as we expected, all got sent back down to the lower courts for additional litigation. So, as we were in the midst of kind of the most critical juncture yet of litigation in these cases, the firm decided that, they were not interested in continuing to have those clients, and were not interested in continuing to have us if we insisted on not dropping our clients after our big win at the court.
And you and Paul wrote an op-ed discussing this that was published in the Wall Street Journal. It's called "The Law Firm That Got Tired of Winning." I love that title. I don't know if you came up with that or if that was something that the editors at the Journal did, but it's a great title, and it's a great piece that lays out your rationale for deciding to leave and start your own practice. Tell us a little bit about how that transition has been, and was it hard to make that decision? I mean, it's in some ways it seems like an easy decision, sort of morally and ethically, but always difficult to untangle a partnership and stuff like that and go out on your own. So tell us a little bit about your thinking there.
Yeah, it's a tough situation, and there was a lot about it that was, was hard and sad. I mean, for the most part had a very good experience at Kirkland, and I think Paul would say the same thing. But I would also say that the decision was the easiest part about this, and it was easy, for both because we'd essentially both already made it before, but also because it's just obviously right. Anybody who knows Paul probably knows that he left a previous firm over a similar ultimatum, and I was working with him at the time and left with him, and have been practicing with him ever since. We've been practicing together for over a decade at this point. And part of the reason, a big part of the reason I left back then was because I believed very much in the stance that he took. And it's the same stance we took now, which is, look, it's one thing to make decisions about the cases you take on in the first instance, about who you want to be your clients. But once you take on clients, I mean, sure, law is a business, everything's a business, but we're a profession with professional obligations and obligations that we owe to our clients, wholly apart from what some may think is in sort of the business interests of a firm or a practice. And you just don't kind of fire your clients because you've decided that they're a little too unpopular or too many people are complaining or whatever it may be. And I think the big problem once you cross that line is, how do you draw the line? And I think there's a lot of great colleagues I had at Kirkland. I had conversations with them about this that struggled to kind of understand the firm's thinking, and some clients that struggle to understand this. And when your client asks, well, if you can do this to them, like, what's to stop you from doing it to me? I really don't know what the answer is. If you have that view that it's okay to abandon your clients kind of mid representation, not because, they stopped paying their bills or they're not cooperating with you or anything they did wrong, but you just decide you really would rather not be affiliated with them anymore, particularly if the reason is because their cause is sort of unpopular with some people. I mean, that's what we do as lawyers. We're supposed to be there for people who have a hard time finding representation.
I have a quick question, and I don't know how much you feel you can speak to this, but in this particular case at Kirkland, how much do you think this was a genuine feeling on the part of the partnership that they did not want to have clients like this anymore, as opposed to pressure from the outside or from younger associates? And I ask because, I know of other firms who have been, pressured by law schools where they hire, that, they don't want to send people to interview at these law firms if they're going to represent such and such client. So I'm just sort of curious whether there was outside pressure or whether this was actually an organic sentiment.
Yeah, that was really my question as well. Like, from what direction is this pressure coming within the law firm?
Yeah. And, frankly, you probably should get someone from Kirkland on here and ask them. But my best sense of it is that it was, a little bit of a combination. I think there was definitely some degree of outside pressure. I think there was some degree of what I would call kind of a combination of the two, which is inside pressure, saying they're concerned that it's causing, that it's, that you're running into the recruiting issues with students or whatever it may be, so, I'm quite sure there were plenty of people who called and complained that we did this work. On the flip side, I'm quite sure there were plenty of people who called and complained after the firm decided to abandon this work. So I think that's one of the risks is, you always hear from the people who are complaining about what you're doing, and they're usually the loud ones. And you're not hearing, you don't get a lot of calls just being like, hey, chairman of the firm, I just want to tell you how happy I am that you're doing, this type of work or this type, because you're more likely to get the people who want to kind of make an issue of things. So I think that's part of what, law firms and everybody, frankly, has to be a little careful about, not just listening to the loudest voice in the room. But, my sense is there was some degree of both, but, ultimately the it was certainly not a decision made by me. So yeah, my insight is imperfect.
What are the implications then going forward of this? I mean, Jennifer was just saying this is not the only time this has happened. You yourself and Paul have had to leave a previous firm. What are the implications of there being only a handful of kind of top flight firms like yours that can handle what are, I don't even want to say unpopular cases, because I don't think they actually, all polling shows that this is a fairly popular thing, but they're unpopular within a certain elite circle. I mean, what are the implications for the rule of law, for like the ability to get representation, when overwhelmingly these large law firms are starting to dump issues one after the other as basically untouchable?
Look, it's all really, it's very unfortunate, and it's not good for the profession. You shouldn't kind of have to go and practice at some, at a boutique just to be able to do issues that come from a certain political perspective that, as you say, while popular with a lot of the country, just happens to not be popular in certain circles that speak loudly in the boardrooms or within the firm committees or whatever it may be. And I think on the one hand, the good news is there are plenty of people. I mean, we're not the only firm out there that have said, what, it's important to us to be able to do lots of work and left and set up their own shop. On the flip side, I do think, I mean, that's frankly, it's easier to do if, like me, you're an appellate specialist. You can go and set up a boutique law firm and handle the kind of work we do. It's a little harder if you don't have the ability to access a big firm. If, say, you have one of these cases that needs to go into full-scale litigation with a lot of discovery and the type of thing that a lot of boutique law firms are just not, I mean, that's not to say there's some really great boutique trial law firms, but, it's a little harder to have the scale to handle that kind of litigation. So it can become a real issue there. And frankly, I mean, it just shouldn't be, it's not good for the development of law across the board, whichever side of issues you're on, to kind of just have like, oh, certain people in certain firms handle one side and one the other, because part of what makes you good at the job is being able to get out of that mind frame and just think about it objectively and come at an issue from the perspective of somebody who might not have your own instincts. And, we like to have people in our practice who have completely different instincts. There's just kind of like, I often say, when you're doing, a moot court to prepare for argument, I mean, it's great to have somebody who wants to come in and kind of ask what they think are the questions that Justice Sotomayor would ask. But like, there's no substitute for having someone who actually thinks like Justice Sotomayor come in and ask the questions that's on their mind. And if you don't have a practice and a firm where you have people that actually have those different perspectives, and where you challenge yourself to take cases that come from different perspectives and try and make the arguments even when they're not the ones that strike you at first blush as where your own instincts lie. I mean, it actually, I think it's detrimental to the development of lawyers and ultimately the development of the law.
You see it, this type of thing happening a lot in terms of the pro bono practice at law firms, where young associates are encouraged to get experience by taking on, cases pro bono, and sometimes, coming up with their own ideas of pro bono work, but then only to find that, certain types of pro bono work are not tolerated at the firm. Usually, in my experience, I've seen that come up when a young associate wants to do some sort of pro-life litigation or litigation or pro bono work on behalf of a religious organization. It usually often gets shot down. But this is bigger because this, when you're talking about paying clients, I mean, it seems contrary to good business to turn away paying clients, right? Regardless of what you think of their issues. But I guess I guess they don't care about that. They'd rather lose the money.
Well, I mean, when there's up and downsides of being at a big firm, and one of the upsides of being at a very, very large, very well-run firm is they endeavor to not be dependent on any particular client, and to be in a position to be able to to turn things away, big and small. But it all still, you're really just talking about something fundamentally different once you cross that line of saying we're not just going to not take on the paying work, like we're going to fire the clients. And if you're going to fire the paying clients, I don't know why you can't fire the pro bono clients that become unpopular too, because again, once you've kind of decided that it's an appropriate basis to terminate representations, that you just don't really kind of want to represent them anymore. I don't know what standards you articulate to decide which cases kind of fit and clients fit into that bucket. But to your point, I do. There is also, I mean, this is a universal thing across Big Law. I think there's just an extraordinary double standard when it comes to, the pro bono cases and all these things, where if you kind of go in with one type of case, you'll be told that's just too controversial for the firm to do. And then you'll kind of see somebody show up on the other side of the exact same issue, and somehow the firm doesn't think it's controversial if you're taking the position that they don't consider a controversial one, which really, it's one thing if you just want to say, well, we're hands off, and some firms approach it this way, but we're hands off on certain hot button political issues. We're not going to do it on either side. It's just
right. Oh, that's totally different.
Yeah, but if you're telling associates like, look, we can't do anything in the abortion space because that is just too controversial. Oh, but we're okay if it's pro. What we really mean it's
right.
If you're on the pro life side, it's too controversial. Like that's where I think associates have found it very frustrating.
It really has implications beyond the private practice of law, because you start to see it in the law schools, where there's this sense that, there used to be a sense that this is an adversary system. Everybody's entitled to counsel, the good, the bad, and the ugly. And you have two sides. You come in, they make arguments, they hash it out. And that's how our legal system works. But now there's this notion that certain people and certain causes aren't worthy of representation at all, aren't worthy of even being on that equal footing. We saw a classmate of mine, actually, Ron Sullivan, who was teaching at Harvard Law School, got a lot of pushback when he represented Harvey Weinstein. And he was, at the time, I guess, a resident advisor or a master of the college at Harvard, whatever they called it at the time. And Harvard came under enormous pressure not to renew his contract, not to teach, but to be the residential advisor of the college, because of a client he had taken on. And, I'm no fan of Harvey Weinstein, but the man deserves a lawyer. So, you see this not only in terms of firms, but you see it in terms of even the way society understands our basic adversarial system, which I find very troubling.
Yeah, no, and I'd say two things. One, like, I think all of this is very wrapped up in the whole broader issues going on with free speech right now, and the idea that it's affirmatively okay to try to silence one side of the debate. I just think that's so antithetical to our constitutional tradition and everything this country's founded on. But it's just a variation of the same thing. And really, part of me, it's just, I have the same reaction to this, that to those kinds of efforts to prevent people from getting representation, that I have to the whole First Amendment debate. It's, what are you so afraid of them having a good lawyer for? If they don't, if this cause is wrong and it's not supported by the law and all of that, like, even the best lawyers are probably not going to prevail. So why not help the courts out, let them feel like everybody, that's what our whole criminal justice system is built on, the idea that we want criminal defendants to get the representation they should have, to have the rights they should have, so we feel confident in the ultimate judgment of the court. And when you start thinking about it as like, no, we're so afraid of one side prevailing that we don't even want them to have like good lawyers or any lawyers who will show up and represent them. I mean, it just displays a remarkable lack of confidence in the rule of law to sort out in the end, which side is right.
Well, and I mean, you see that, and just a few days ago, the New York Times came out with a piece essentially from two constitutional law professors arguing that we should basically scrap the Constitution. So, I mean, I think that's also connected to all of this. But I wanted to ask you to wrap this up. A big question. So feel free to maybe tackle only a small piece of it. But what kind of changes or reforms do you think would stop this larger train of, because there seems like there's multiple sides to this. There's the issue Jennifer mentioned where you have increasingly woke law schools where the students don't recognize, for example, the merits of an adversarial system, like what you're saying. You have students who don't believe that the First Amendment should exist and don't care that it does exist, right? And then there's the larger, sort of broader phenomenon of woke capital. We see this in other institutions as well. There seems to be like a larger institutional warfare going on with this ideology. Within the law, can you think of any reforms, whether that's, sort of who needs to stand up and take a little personal courage, or like more systemic reforms, like looking at what the ABA does, or, what do you think would stop this train? Because it seems like it's going in towards a destination that is getting quite scary.
Yeah. So, I mean, I guess I have, just a couple of rather big picture generic thoughts. I mean, one is, just because some people are very loudly questioning the foundations of our nation and our Constitution doesn't mean those rights cease to exist. And so it is important to take the right issues and push them in the courts, and the courts need to do their job and step in. And, we do thankfully right now have a Supreme Court that has consistently been very protective of First Amendment rights. And, that there's a lot of issues. It's difficult to litigate these things because I know, the university speech codes and stuff. I mean, everybody understands how to try and moot cases and do all of that to prevent them from getting to the courts because they know they're going to lose. But I do think it's important to not lose sight of, some of the things that are going on here are not just discussions that are startling to hear people taking certain positions, but actual actions that are challengeable in court. And we should take advantage when we can of stopping things, especially at the schools, at the public schools, where you have the ability to bring First Amendment and other types of challenges if, when you have things going on that are just antithetical to free speech principles. But I think part of the more fundamental issue is, so much of this is a product of people, of the decision makers hearing certain voices and thinking there aren't others, or that the others don't care enough or aren't loud enough, or there aren't as many of them, or whatever it may be. And I don't think, that that's universally proven true. I think in many of these instances, you can see, whether it be firms or companies or whatever it is, who kind of listened to those voices, then find themselves in some real trouble with some people they didn't anticipate, whether it be their consumers or whatever it is, when they're on the other side of a decision they made that actually turned out to be a lot less popular than the very loud woke voices led them to believe it would be. So I think part of that is, it's incumbent on all of us to not let the voices of people who are really kind of thinking about radically reshaping our constitutional rights to completely outshout, the voices of people who can explain why, no, that's it's because we have a First Amendment that where you can have this kind of dialogue where you wouldn't be able to even make these arguments in many other countries throughout the world, and to keep talking and helping people understand the other side, and to help, especially with young people, with students and young people starting in the workplace, to help them, assure them that they're not like some disfavored minority. There are other people out there who have conservative views or libertarian views, or even just like not completely anti-establishment views, and that it's okay. We can speak together and acknowledge that, and you don't have to kind of secretly hide in the corner or have here's the lunch nobody knows about, where the conservatives get together and acknowledge like there's a few of us. We help people feel more comfortable talking. I think that's one of the very first and very most important steps in all of this, especially with younger people, so they don't kind of just grow up in an educational and work culture where they're like really, led, maybe not even incorrectly, to believe that it will be detrimental to everything in their career if they acknowledge that they don't agree with what, the loudest voices of the day are saying.
With that, I think we'll probably wrap it up. Thank you so much for joining us, Erin Murphy, and also thank you to our listeners for tuning in to another episode of At the Bar. Jennifer, you want to wrap us up?
Sure. At the Bar is a production of Independent Women's Forum. It's available for viewing on Facebook, YouTube, and IWF.org. And you can listen to At the Bar as a podcast on iTunes, Spotify, iHeartRadio, or anywhere else you get your podcasts. Join us in a few weeks for another spirited conversation about issues at the intersection of law, politics, and culture. Until then, cheers. Thanks for joining us.